25, People versus Michael Jackson-Bolanos. Appearances, please.
Good afternoon, Your Honor. John Boyd Hall for the people.
Dominic DeGrazia on behalf of the people.
Brian Brown on behalf of Mr. Jackson-Bolanos.
Good afternoon, Judge. Perna Krishnamurthy, co-counsel on behalf of Mr. Jackson-Bolanos, who appears to my immediate right.
And I know for the record, Mr. Jackson-Bolanos is present, as are all counsel, and you may be seated. So we have a motion to take care of first, and then sentencing on the charge he was found guilty of. I did review the defense's motion to dismiss based on double jeopardy grounds and the case of Yeager versus United States. And the defense is saying that that precludes retrial of both the felony murder charge and the home invasion first degree charge. The people, although disagreeing with the findings or the rulings in Yeager and plan to appeal according to their brief, the actual findings in Yeager, or the holdings in Yeager, and arguing that it's bad law, concede that the court has to follow the precedent set in Yeager in granting the motion to dismiss with regard to felony murder charge, if I'm paraphrasing correctly, but not as to the home invasion first degree. So I guess I'd like to have the people address that, and then I can have a response from the defense.
Certainly, Your Honor. The court has accurately indicated what our position is that as to the felony murder charge, the Yeager versus the United States opinion basically says that the jury has made an ultimate finding of fact. In this particular case, they found, based on the not guilty verdict as to the premeditated murder and the lesser second-degree murder counts in that. By finding that, they found that the defendant did not commit a malicious murder in this particular case. That finding in itself precludes a retrial on the felony murder charge, which, you know, as this court well knows, is that basically what felony murder is a malicious murder committed during the commission of a felony. So we do concede that what Yeager holds would require this court to dismiss that particular charge, the felony murder charge. We do object to that because we do intend to seek an appeal to the Supreme Court, and do seek, we'll be going through the state courts on our way to the U.S. Supreme Court. As to the other charge, the home invasion charge, also relying upon Yeager versus the United States, we do not believe that there is a similar or a common ultimate finding of fact between the acquittal in this particular case, the murder, and the home invasion. The standard that Yeager sets out is whether a rational jury could have grounded its verdict upon any issue other than what the defendant seeks to foreclose, which being the malicious murder in this particular case. I think it is rational for a jury to believe, based on the facts that were presented at this case, the evidence that was presented during the trial, that it is rational that the defendant did go into the house, did go into Ms. Woll's house, without finding also that he was the person that committed the murder in this particular case. As the court is aware, why Mr. Bolanos was in this area, why he was even in Lafayette Park at this time, was he was committing a series of opportunistic larcenies throughout the city, throughout the area. And that's what brought him to Lafayette Park. So it is rational for a jury to believe that he continued with that the seeking of opportunistic larcenies in the area by finding either before the murder or after the murder, finding the house, Ms. Woll's residence, available and open, and then taking advantage of that and went into the location seeking to do another larceny. So I think a rational, based on the facts that were presented in this case, even if the jury was to find that the defendant did not commit this murder, there is still evidence for a rational jury to believe that he did commit the home invasion.
Response?
Yes. Well, I guess since they concede the felony murder, we don't have to really address that issue. But as far as the home invasion, quoting Yeager, the issue preclusion portion of double jeopardy is a different analysis, where you don't necessarily look at the elements of the crime of which an individual seeks to have that issue precluded or that particular offense precluded. But you will look at the arguments that were addressed at trial and the evidence that was presented at trial. At trial, their theory was that Mr. Jackson-Bolanos went inside of this particular house to commit an assault. That was the predicate under Home Invasion 1, that Mr. Jackson-Bolanos went into this particular residence to commit an assault. The jury found that he did not commit any type of assault. He was acquitted of first-degree premeditated murder and the lesser included second-degree murder. So under their particular theory, that issue has already been addressed. So the inquiry is whether or not in the second trial, a jury can conclude, even by an inference, that Mr. Jackson-Bolanos could be convicted of home invasion first degree without being convicted of a murder, which they cannot. Because, like I stated, the predicate for their home invasion was an assault. So how can, at a second trial, the jury will be in a position to find that Mr. Jackson-Bolanos committed home invasion first degree if he didn't commit any type of assault on her? So they basically want another bite at the apple, and they want to change their theory and say that, oh, okay, our new theory is that he didn't go in to commit the murder or an assault, but he peeked in there while she was present before the murder or after the murder, which no evidence substantiates that theory at all. They're just throwing things at the wall, hoping something sticks and changing their theory. They've already unsuccessfully argued their theory, and for them to get another bite at the apple, Judge, that'll be against precedence. So, Judge, saying all of that, we feel that home invasion first degree was already litigated. That issue is precluded from any subsequent trial, and both home invasion first degree and felony murder needs to be precluded. And I wanted to address just their second theory. Their second theory was, even if it's not logical, because it's not, even if it's not logical that a home invasion first degree could be recharged based upon the lack of an assault because he was acquitted on that, we could then try to charge him with home invasion second degree. Basically, they're trying to say that, her body was outside, he didn't do the assault, but he went inside of her apartment after she was already committed. After all of this blood was located inside of the apartment, somehow he went in there and triggered the motion with no footprints near the door, no footprints in the apartment, but somehow he must have or could have went inside of this apartment after she was already murdered. And that's just preposterous. That's just another unsubstantiated theory with no evidence to support that. And they've already had their opportunity, and they unsuccessfully argued it under the predicate that they asked this court for. They asked this court to instruct the jury to decide whether or not he would be guilty of home invasion first degree under an assault, not a larceny. So now they want to say that, it's reasonable for a jury to decide that, he was doing opportunistic larcenies throughout the city, so it's reasonable for a jury to conclude that, he was still in that opportunistic mindset when he walked into the apartment. No, they didn't argue this at trial. Their theory was he went in there to do an assault, not a larceny. And we questioned that while we were preparing the jury instruction. Like, this is what you want, right? That's what they wanted, that's what they got, and they did it unsuccessfully. They don't get another chance, Judge. Thank you.
Reply?
My memory of what our theory was is that we charged it as felony murder with the underlying being a larceny. So the reason for going into this house in the first place was to commit a larceny, not to go into this house thinking that he was going to assault Miss Woll if he happened to find her in That was, I believe, our theory. That's how we charged it. The jury is not bound by what our theories are. They're bound by what the evidence is presented. And what the evidence that has been presented, would it be rational for them, based on the evidence that was presented, for them to find a home invasion even without finding that he committed the murder? Our position is yes.
And just a quick reply. He states his memory. He didn't participate in this trial, so his memory may not be at where it should be in order to, I guess, recite what the elements were and what the jury instructions were.
I've got the instructions right in front of me.
Okay. All right.
I just had my law clerk print them off for me.
Okay.
These are the ones I read during the trial.
All right. Thank you.
So in a way, he is correct, because under the felony murder charge, they had the crime of larceny and or home invasion.
But he was acquitted for that.
I understand.
Okay.
But so he's correct that under the felony murder, their theory was larceny and or home invasion. But under the home invasion, we had discussions about this before the trial began, and in the information itself, count 3 home invasion alleges that the defendant did break and enter or did enter without permission a dwelling located at Joliet Place in Detroit, and while entering, present in, or exiting from, did commit an assault. And while entering, present in, or exiting the dwelling, Samantha Woll was present, legally present therein. So the only theory under the home invasion charge in the information was committing an assault, not the theft theory. And in jury instructions that were given to the jury on count 3, the second element was that the defendant entered, was present, that when the defendant entered, was present in, or was leaving the dwelling, he committed the offense of assault and battery. And nowhere in the instruction on home invasion first degree did we talk about larceny. And that was not in the people's information either, under the theory for home invasion first degree. So, it would seem that the underlying theory of assault would also be barred, and that is not, and there was no mention of the home invasion of larceny under the home invasion, both in the information and in the elements that were given to the jury. So I believe, as Jaeger still appears to be good law at this time, the court is also precluded from retrying the home invasion first degree because it was based on the assault and battery theory, and obviously assault and battery would carry on with the ultimate crime of felony murder and the attack that happened to Miss Woll. So I believe that based on the theories presented by the people in the information and in the instructions as were agreed by the people in defense, home invasion first degree would be precluded as well. But I do want to address the Jaeger opinion. I did pore over this opinion quite thoroughly, and I do agree with the people that it is a poor decision and presumes that when a jury makes an inconsistent finding of being hung on one count but finding not guilty on the other count, that it must be that the not guilty applies to both. And after listening to this trial and listening to all of the emphasis that was put on felony murder, and basically the people barely mentioned first degree premeditated murder in their openings, closings, or anywhere throughout this trial, the main focus, and I believe the prosecutor even said, the main focus of this trial is the felony murder. And there were still jurors who were voting for guilty on felony murder, and they were hung as to that count and as to the home invasion first degree. I don't believe this jury had any idea that when they found him not guilty on the premeditated first degree murder, that they were precluding a retrial on the felony murder. Inconsistencies, the jury can't be charged with knowing that realizing the elements of second-degree murder are essential for the elements of felony murder. They're not legal scholars. They're looking at this as separate types of charges. And I think that Judges Scalia and Alito were right when they were saying that under all of the prior rulings prior to Yeager, that a jeopardy continues until a hung jury is able to deliberate and return a verdict on all counts. But I am bound by Yeager, and I can't ignore precedent that's been set by the U.S. Supreme Court. And so I am going to have to dismiss as to both the felony murder and the home invasion first degree. I assume the people are going to appeal this decision and see what happens from there. We are today here, though, and he was acquitted on the first degree premeditated murder, so then that leaves the count 4, lying to a peace officer, and we are here today for sentencing on that charge for which the jury did find the defendant guilty. And have all parties had an opportunity to review the pre-sentence investigation report?
Yes, sir.
Yes.
Are there any corrections, deletions, or additions to the body of the report?
Yes, to the body of the report, we would object to mention of all acquitted conduct for Mr. Jackson-Bolanos. They go through a lengthy recitation of what the investigation consisted of, what the police did as far as charging him with murder, and we would like all of that stricken from the pre-sentence investigation report. I believe the only information that should be contained in the pre-sentence investigation report is any information pertaining to his conviction of lying to the police.
Yeah.
I'm sorry, in regarding larceny from a vehicle, not lying to the police in regards to touching her body or anything.
Your Honor, this exact argument was raised in People v. Stokes. That's a Michigan Court of Appeals case at 333 Mishap 304. The defendant in that case objected to information about acquitted conduct being included in the pre-sentencing report. Michigan Court of Appeals stated that it was not an error for the judge to be aware of that information as long as the court did not use acquitted conduct as the basis for her sentence. And I don't believe, I would not ask the court to use acquitted conduct, and I don't believe the court would. So following People v. Stokes, there is no merit to this argument.
And I believe the court is very aware of the facts and circumstances of this case, seeing that the court was present for a 5-week trial, so I don't believe that the information contained in the pre-sentence investigation report is necessary to inform or refresh the court's memory of what the allegations or the investigation was.
Well, you're talking about the description of the offense narrative, and that is taken directly from the police department's investigator's report. And I've never stricken any parts of that investigator's report. That is how they came about to this whole thing. It is noted in here at the end what happened with the various counts, and so anyone reading this will realize that what had happened. I do note on page 5 of the evaluation and plan, which is the end of that narrative of the description of the offense, that it didn't actually say what happened to count 4, and so I added the sentence at the end of the last paragraph, right before it says consecutive sentences. The defendant was found guilty by jury of count 4, lying to a peace officer.
Okay.
Because they didn't say what the result of that charge was.
And Judge, just if we could add just the language that he was convicted of lying to a police officer and regarding an investigation about larceny from a vehicle. So I think there might be some type of confusion. I know the court may not be confused, but there might be some kind of confusion of what he was convicted of about lying to the police about. I think there might be some confusion that he was convicted for lying about the knowledge of Samantha Woll, which is...
Well, I could say peace officer for a felony punishable by 4 years or more.
Okay.
That's what they have, how it's listed. That's the name of the crime. So, Are there any other corrections, deletions, or additions being requested at this time to the body of the report?
None on behalf of the people.
Not to the body, just some guideline issues.
Mr. Jackson-Bolanos, is there, you went over the report with your attorneys?
Yes,
All the information about yourself is correct?
yes.
Okay. I also want to note, under the prior offenses, there seems to be some discrepancy from the 2013, the adult history 1 of 1, or 1 of 3, I'm sorry, on page 8 of the report, at the bottom, it says 8. Adult history offense 1 of 3.
Yes, sir.
It says that defendant was resentenced to a prison term there was a narrative further in there, but it looks like his HIDA was revoked and he was sentenced to a prison term, but then there's also something in our Odyssey system indicating that it was closed under HIDA, so there's an inconsistency in there, and if
I would say Haida, he was closed under Haida.
well, no, but he was resentenced to a period of prison term, and he served the full 5 years, and so that's not legally possible, that you could do that. And so, that is being brought to Judge Deborah Thomas's attention. She was the judge on the case, for her to make any correction to the record that may need to be corrected, because it is, inconsistency, to say that HIDA was revoked, and he was sentenced to prison for 18 months to 5 years, and served the full time and never was discharged on parole. He served till the discharge date, and then somehow it said closed under HIDA. So it's not legally possible to do that.
Okay.
And so Judge Deborah Thomas we pulled that file. She'll have to take a look at that, to look at that inconsistency and make any corrections she may need to make to the court file. I just wanted to note that for the record, that we were looking at that, noted that.
I saw that too.
Anything further with regard to changes, corrections, deletions, other than the guidelines?
From my perspective, no.
And with regard to the guidelines, I know I received an email from defense arguing that OV-19 should not be scored at 10 points based on a rather recent Michigan Court of Appeals, or Michigan Supreme Court opinion, which there was another dissent. Did you wish to address OV-19?
Yes, I believe it is scored properly. I've had a chance to look at the case that defense counsel sent this morning. That case basically stands for the proposition that there must be something more than a suspect's denial of the accusations. And this was in the context of a one-off statement in the course of a search warrant that was executed at this Mr. DeWeird's home. What we have here is very different. And I would point to the cases that are cited in this DeWeird case, People v. Barbie. That's
you
an
spell
example.
that?
Sorry, what?
Spell the name for the court reporter, please.
B-A-R-B-E-E. That's at 470 Mich 283. In that case, the suspect provided a false name to police, and the Supreme Court has upheld that as a valid a valid scoring of OV-19. The central question for determining whether there has been a violation of OV-19 is, did the ultimate effect of what the actions of the defendant were meant to conceal his guilt in the manner that was being investigated, or the administration of justice. And what we have here is the defendant's repeated lies, knowing that he was being investigated for larceny from a person. When he testified, the defendant testified that the reason he was lying to the police was because he was afraid of being arrested and charged with a crime because of the potential punishment. So this goes far more than simply a one-off statement during the execution of a search warrant. This was a deliberate pattern of misdirection, concealment, and deception that the defendant engaged in knowingly and willingly because he was afraid of the consequences of being honest. So when you look at the cases where the courts have upheld the scoring of 10 points for OV-19, lying to the police to hinder investigation, destroying evidence, providing a false alibi, providing a false name, all of those types of behaviors have been upheld as valid scoring of OV-19. And in this case, the defendant is convicted of lying to a police officer, which in and of itself would seem to qualify under OV-19. But if we're looking for something more, it's the deliberate pattern of deception, knowing and purposefully to avoid arrest by the police. So I believe it should be scored at 19 points.
And that analysis is just totally factually incorrect. The D-word case stated that a lack of culpability does not indicate that OV-19 should be scored. It has to be something more. Barbary, it was an attempt to conceal his identity or conceal evidence. Other cases, such as if an individual flees from the police or hides from the police. And the court stated, People v. Dixon stated that if you use a lack of culpability, basically not admitting to the allegations right there, then OV-19 is boundless. Then you'll be able to charge somebody under OV-19 if they remain silent. You'll be able to charge somebody under OV-19 if they decide to go to trial despite having overwhelming evidence to the contrary of their innocence. You would be able to charge them under a plethora of different circumstances where OV-19 has not been or supposed to be used under those circumstances. An individual has a presumption of innocence. So if the police ask you, did you do this crime? And then you say no, that does not impede their investigation any more than if you remain silent, per case law. That's what the court stated. So if he were to remain silent, or if he would have said what he said as far as that's not me, it has no other impact or no more of a detrimental impact on their investigation at all. He didn't say, oh, I know who did it, it's John down the street, and then they went to investigate John down the street. Had that happened, then yeah, maybe OV-19 would have been applicable in this particular case. Or if he tried to come up with a false alibi, and then the police had to expend resources to track down who he said he was with, like I would my ex-girlfriend, they had to go track her down, call her, interview her, just to find out that he lied. Under those circumstances, yes. But just him simply coming to the police station and saying, I did not do what you accused me of doing? Judge, clearly the case law says that OV-19 cannot be scored under these circumstances. So it's not valid.
Well, I think I'm bound by DeWeerd, and that's spelled D-E-W-E-E-R-D, and that is 511 Mich 979. That's a 2023 case that came out of the Supreme Court. Although there was a compelling dissent written by Justice Viviano and joined by Justice Zara, but that's...
I mean, Judge, this goes more than just a denial. He didn't just go to the police and say, oh, I didn't do it. He engaged in a deliberate pattern. He did give a false alibi. He did lie about the circumstance of what it did. All of these factors that are mentioned in DeWeerd, where they're saying that,
What's false alibi?
Yeah, exactly.
he claimed he was at a gas station. He claimed he was at his aunt's house. He claimed he wasn't even there breaking into houses all night. The police did have to run down these different
He doesn't
leads
remember
and
the
check
facts.
these things out.
Hold on.
Breaking into houses? What is he talking about?
Cars, you mean.
Cars, that's what I meant.
That's what he's talking about.
He's claiming he was doing other activities. He was in completely other places. He said he was, I was at my aunt's house. I was over here talking to a girlfriend. I was doing all these other things other than what he admitted that he was doing, which is lying to the police. So there's clear distinguishing here between DeWeerd and the other cases that the court in DeWeerd said were still valid uses of OV-19.
And his remembrance of the facts is flawed at best and disingenuous maybe at worst, or maybe flat out lies at worst. However, he never said he was at a girl. Sergeant Ford said, who are you talking to? We see you talking to somebody on the other side of the wall. He's like, I don't remember. I don't know. I know somebody who stays in the Kingdom. I don't know if I was talking to her. And then furthermore, and it was about an hour into the investigation that they even told him where or what day this happened at or where it happened at. He never had a false alibi and said, I wasn't there. They asked him about a bag and he was like, oh, I might have, got it from a gas station. They didn't say, oh, on October 21st or October 22nd, you were seeing Candace's bag. They showed him a picture of a bag walking downtown and say, oh, what's in this bag? Like, if you can show me carrying a bag from Whole Foods and like, oh, I know you went to Whole Foods. I can't remember what day that was at. It could be on any day. Judge,
I was already ruling in your favor.
I'm sorry.
so
I'm just wanted to. I know. I'm sorry. I apologize. It just.
OB 19 will be at 0.
Thank you.
Takes us to 0 for OBs down to level 1. Any other objections to the guidelines?
Yes. PRV 1 is improperly scored at 25 points. I believe they're double scoring his previous conviction for juvenile. They already scored that under a high severity juvenile conviction, and then they in turn scored it under a high severity adult history, which there is no adult high severity convictions under Mr. Jackson-Bolanos' record. So that should be scored at a 0.
No. The 2018 conviction, which is adult offense number 2 of 3, he was charged with receiving, concealing stolen property as second offense. And that's what he pled guilty to. So that receiving,
Which is
concealing,
what, 7.5 years?
Yes, it goes up to a level D offense, which is a high severity felony.
Do you contest that?
I contest, yes. Absolutely.
All my guidelines. Do we have the PSI from that sentencing?
Right, and I believe they dropped the habitual status, representing him on that case. He wasn't sentenced under habitual status.
Yeah, hold on. Well, it says in the history that he was, but let me look and see what it says in our court. What's the case number? Hold on. Well, it says stolen property, receiving, concealing motor vehicle, second offense. In the records, I do not have the documents available to me.
In the guideline book, it is listed as a level D, which is a high severity.
Hold on, let me pull it up. What's the PEC code?
750-535, paren 8.
5358.
Yes.
Yeah, second or subsequent offense is a 10-year penalty, which would make it a level D. Which does make it a high severity. So OV, or PRV 1 is correctly scored at 25 points. Any other objection to the scorings?
No, no other objections to the scoring. So that would put the guidelines at 0 to 22.
That's correct. Under the G grid?
Yes.
Do you concur?
Yes, sir.
Anything further that people would like to state before I impose sentence?
Yes, sir. When the court imposes sentence, I think there are a number of factors that I think the court should consider. I want to particularly talk about the defendant's previous criminal history, because I think they're reflective and it's something the court should consider. 2011, the defendant was first adjudicated as a juvenile for robbery unarmed. He was convicted of that, or adjudicated for that, despite his testimony at court that he had never been convicted of a robbery crime, which is obviously false. But he was placed on probation in October of 2011. Within a short period of time, he had a violation of probation for picking up a retail fraud case. Within a few months, he was then committed, which is a elevated punishment within the juvenile justice system. So already, within 5 months of his first adjudication as a juvenile, he's already violated his probation. Ultimately, his probation is terminated, and in 2014, that's when he gets his first adult conviction in the justice system for fleeing and eluding in the 3rd degree. Again, he's given a break where he is placed on probation under HIDA status. I assume that he was supposed to complete some sort of boot camp program at the Thumb facility, but obviously he failed, and he failed within a short period of time on that. His probation was revoked, his HIDA was revoked, and he was sentenced to prison. While he was in prison, he was adjudicated and found guilty of over 40 misconduct offenses while he was in prison, including possession of stolen property, threatening behavior, fighting, assault on a staff, sexual misconduct, 40 adjudications of guilt within that 4-year period of time. He is released from the Department of Corrections, and within 5 months, he has now been convicted of another felony for receiving and concealing stolen property, second offense this time, and he is again given a break where he receives 2 years probation and the 6 months in the Wake County Jail, and that's after serving 4 years in prison and committing a new crime within 5 months of being released. After he is placed on probation in 2018, he again violates his probation, again repeatedly. And all that is to say, Your Honor, that the defendant, whenever he has been out in the community, he has committed more crimes. Even at the time of this alleged offense, and we'll get to this in his testimony, he was again engaging in criminal behavior, even though he was not under any sort of court supervision. Now, in terms of the offense that he was convicted of, I think it's important to note that lying to a police officer is not some victimless crime that is of no importance or that isn't serious. Lying to a police officer during a criminal investigation is how innocent people get convicted of crimes, because law enforcement, prosecutors, we are relying on people to tell us the truth about their activity, and when people lie, that's how people get caught up in the system. And you have the defendant here who lied repeatedly, had testified under oath that he was constantly lying or consistently lying throughout these police interviews, and he's offering to tell the police about drug houses, about human trafficking, about auto theft rings. He's eager to tell the police information which obviously would have likely been false, but could have possibly resulted in some innocent person being arrested. So that this is not some victimless crime. And there were probably many hours spent in the course of this investigation chasing down leads, chasing down the defendant's false alibis and other lies that he gave during his statement. So the police time was used. We were all in trial, contesting every single point, every bit of evidence. And the defendant has a right to contest the evidence against him. But after all of that, he comes and he testifies and he essentially says, oh yes, everything I told the police, that was a lie, and the evidence that the prosecution has put forward, that was accurate. that's the result of his consistent deception to the police, wasting time, forcing the police and law enforcement to do things that they otherwise wouldn't have done but for the defendant's deliberate decision to lie to the police. Now, in the Stokes case that I cited earlier, the case is clear that the court may consider conduct that is relevant to these particular crimes and the res gestae of the case of the crime itself, even though the court cannot consider acquitted conduct. So when we talk about the other facts and circumstances which were surrounding the defendant's reason he got into a police interview room and was lying to the police, first of all, the defendant admitted when he testified that he committed a larceny of a person, that he considered numerous larcenies for motor vehicles, that the defendant was part of a auto theft ring where he was sending photographs of cars to other people who may have stolen those cars, that the defendant was also scouting scouting cars so that he could later steal them. Those are all admissions he made when he testified. He was also admitted when he testified that he broke into a number of cars that night, at least more than 5 cars. So we have really just a number of victims of his actions that night. And that all is significant. Why? Because it ruins the quality of life for the community around him. Now, the defendant, throughout his statement to the police, and also in his testimony, it was clear that he showed absolutely no remorse for breaking into all these cars, for committing all of these crimes, because for him, the important thing was that, the items that he was stealing had no value, that it was just some property. And I think it was telling when he testified on July 8th, there was some discussion during direct examination about, going into cars, breaking cars, and the defendant said, "I'm not hurting anybody. I'm not bringing any ill will towards anyone." And that's at page 14, line 3. So it's clear that the defendant, when he's not lying to police officers, he's engaged in a criminal lifestyle where he goes around seeking opportunities to commit crimes, and he has no compunction or any sort of understanding in his head that he's doing something wrong. This is a person who was doing all this, according to his testimony, not because he needed money. He specifically rejected this. He specifically was going out there to commit crimes because he liked to commit crimes. He was out there for 4 hours walking around Detroit committing crime after crime after crime. So I think ultimately, Your Honor, when you're considering sentencing, I'd like to point to the People versus Snow case. That's at 386 Mich. 586. The court should consider various factors. The reformation of the offender, protection of society, the disciplining of the wrongdoer, and the deterrence of others from committing like offenses. So clearly the defendant has had opportunity after opportunity throughout the course of his life to reform himself, to stay out of trouble, to stop committing crimes. None of that has worked. He was given HIDA, he failed that. He was on probation as a juvenile, failed that. When he was in prison, he misbehaved. When he was released from prison, he committed more crimes. Even recently, when he supposedly has a job and everything is going great for him, what is he doing with his time? He's going out and committing crime after crime after crime, according to him. So when we talk about him reforming himself, very low possibility of that. We talk about protection of society. Having the defendant out in the community will almost certainly cause more crimes to be committed by him if you look at his previous history. The disciplining of the wrongdoer, certainly in this case, I think it's appropriate to punish the defendant for lying to the police, for all the circumstances that were surrounding of how he got in a situation where he was lying to the police, and deterrence of others from committing like offenses. It's very important that people know that when you go to the police and you deliberately lie to them repeatedly, that there is a punishment for that crime. So given all that, Your Honor, the legislature has given you the ability to sentence the defendant to prison. And his guidelines in this case are 0 to 22 months. I think a prison sentence, given the nature of these offenses, the defendant's previous criminal history, would be appropriate. So I'm asking the court to sentence the defendant to 22 months to 15 years in prison.
Judge, that's just a preposterous request. They basically want you to sentence him for acquitted conduct. The fact that they did not get the acquittal of an innocent man, they want you to sentence him to the maximum amount of time that's available under the guidelines. Judge, now, the prosecutor speaks of innocent people can get convicted of crimes when individuals lie. They also said the resources of the police department. Now, we saw through the pendency of this trial, multiple of their witnesses who've lied to the police, never charged, and what did that lead to? That led to an innocent person who was facing the trial of his life, fighting for his life for something he did not do. Something that was pretty obvious to anybody who paid attention to the trial, that Mr. Jackson-Bolanos was a victim of circumstances of the wrong person at the wrong place at the wrong time. That's all. Now, as far as lying to the police, he admitted he lied to the police. As we stated earlier, he didn't send the police on a wild goose chase. He didn't say, oh, I know who did it, it's George Lewis. He didn't say that. He said, that's not me in the picture. And he said that all of, 20 minutes before he came clean? They didn't even get a chance to leave the room. They, in their mind, knew he was lying. He came clean, and he was very honest and said, yeah, that's me. However, when he denied it at first, like I stated, they didn't give him any specifics of when this happened. They didn't say October 21st, October 22nd, you were in the area of Lafayette and wherever, or you were in the area of Harbortown off of Jefferson. They never asked him pinpointed questions. They gave him a screenshot of somebody holding a bag and said, that's you, you were going into cars. They never confronted him with any type of evidence to suggest, like, oh, we saw you going into the car. And matters of fact, he introduced evidence that they didn't even have. He said, I was out there taking pictures of cars. They didn't have that information there. They didn't confront him with a picture of that Dodge Challenger with Coast Guard plates. He stated that. And after we found out in the trial, that was the honest statement that he made, that he gave to the police. Now, just like OV-19, if an individual denies culpability, surely he shouldn't go to prison for that. He's innocent until proven guilty. It has to be something more. Just like OV-19, it should be something more in order to rise to the level of sending him to prison. Just him initially denying culpability is not enough for a prison sentence. How many individuals lied to the police and they never charged? Through the pendency of my career, I've never heard, never represented an individual who's ever been charged with just simply lying to the police officer, unless it's something super material, such as maybe they filed a false police report, they hid their car down the street, and then they say they got carjacked. And then the police are going out looking for a carjacker, spending all these resources just to find out the person who made that report lied to them. Or in a case where they get on the stand and they commit perjury, like people did during this trial. People committed perjury during this trial. Are they going after them? No, but they want to act like they're so concerned about the truth. Their own witnesses, they knew they were lying. Are they going to charge them with perjury? Absolutely not, because it's not, justice for them is not blind. They look at him and they want to convict him and they want to punish him for something he did not do. And then they want to get emotionally charged to bring up all of this stuff, his prison record. Where's that information at? What prison record? Was that in the PSI? Was that contained in the PSI? He successfully completed his probation in 2018. He's learned from his mistakes. The fact that he was down there, he stole some candy, not minimizing that, he was fighting for his life. If that doesn't change your life, if that doesn't light a bulb in your head or light a fire under you to change your life, I've had multiple conversations with Mr. Jackson-Bolanos. I can guarantee he won't even jaywalk going forward. He won't even forget to blow his nose after sneezing. That's how straight on the path that Mr. Jackson-Bolanos has to be. Because he knows that when he walks out from this courtroom, they're going to be looking for anything and everything to try to charge him with anything. You didn't cross at the crosswalk. That's a ticket. Hopefully we find something on you. He knows exactly that. So he is not going to have any more run-ins at all with the legal system going forward. The probation that Michigan Department of Corrections recommends, and we recommend that also, he's going to complete that without a stain or a blemish. There's not going to be any type of violation, because he knows if he comes in on a violation, the prosecution is going to say, see, Judge, send him to prison. He's not going to give them the satisfaction. He's not going to give them the opportunity. Not just that he doesn't want to give them the satisfaction, because he feels in his heart and he knows in his heart what's the right thing to do, and he's going to act accordingly. Through these 243 days, he's had a multitude of opportunities to reflect on what he did that particular night. Now, he takes responsibility for what he did that particular night. And he knew that those bad decisions has led him in a position right now where he is handcuffed in front of this court. Picture has been posted across the world, across the universe. There's people on Mars who have seen his picture. And initially, before this trial, has associated him with being a murderer. How does that feel? How would that feel, knowing that you did not murder somebody? You just in the wrong place at the wrong time, and then the world is accusing you. They say, oh, the suspected murderer or the murderer. Some news articles call him the murderer. Some call him the alleged. Some call him suspected. But nevertheless, they associated his name, his picture, with the death of Samantha Woll. Now, we feel very bad for what happened to her. But charging him should have never happened, because that's not justice. That's not justice to the family. That's not justice to the community. And that's certainly not justice to Mr. Jackson-Bolanos. Just to get anybody, knowing that the evidence does not point at him. Judge, there was a recommendation from the Michigan Department of Corrections that Mr. Jackson-Bolanos be sentenced to probation. Judge, we're asking you to follow that recommendation. We're asking for an 18-month term of probation, because, Judge, I'm sure you've probably not had many cases or sentencing in lying to the police, because they don't charge that. The only reason they charged Mr. Jackson-Bolanos was in an attempt to stain his character. So when he does take the stand, or at trial, he's a liar. He's a thief. He had to do it. Mr. Elsie, how many times did he say Mr. Jackson-Bolanos is a liar? Oh, he lied 40 times. He lied 44 times. Lie number 1, lie number 2, lie number 3. Yeah, he admitted he lied. He admitted he lied. He's not a murderer, but he also came clean. He also told them the truth. He also told them what happened. Like, yes, this me, I take full responsibility. So 243 days, already incarcerated, fighting for his life, that mental anguish, the depression, the anxiety that goes with those 243 days. Because he wasn't just sitting in a jail cell with his feet up. He wasn't on vacation. Like, that type of mental anguish to be charged with something that you didn't do, Judge, I think is more than enough to ensure that going forward, that Mr. Jackson-Bolanos will be a successful candidate, Judge. And considering the crime in his guidelines, Judge, we ask for a term of probation without the tether, because we believe that Mr. Jackson-Bolanos is not a flight risk. He was arrested twice. The first time he was arrested, he never tried to flee, Judge, so there's no particular reason why he would flee. And he understands if he does try to flee or violate probation, he would be throwing himself in front of the court, and he knows where he would be going if that were to happen.
Mr. Jackson-Bolanos, anything further you'd like to state on your own behalf, sir?
Just that I've heard him before. He was a good in the community.
I still have my job, so I'm working currently. Not right now, but when I'm out, yeah, I don't want to go further.
You may be seated. So, this is a difficult case. We started with some very, very serious charges. While it seems like this is not a serious charge, when you add the habitual fourth offense to it, raises it to a maximum penalty of 15 years. And what I have to look at is not just the circumstances of the offense, but also the offender. And habitual fourth raises this up into a straddle cell, 0 to 22 months guidelines, and the 22 months would indicate prison. And although it is a straddle cell, I could choose to give him jail time or just straight up probation. But I also have to look at the number of times that the defendant lied. And I have to say, if lying was an Olympic sport, you would get the gold medal, sir, because you told lie after lie after lie throughout those interviews, interrogations, and even a few on the stand. And the number of lies does factor into this. Also, the fact that there were prior failures to comply with community supervision, both with an unarmed robbery when he was a juvenile, and also for the fleeing looting. And not only was he removed from the Haida prison sentence at the Thumb almost immediately, but was given a sentence of 18 months to 5 years and served out the entire term and never actually achieved parole because there had to have been numerous misconducts that apparently Mr. DeGrazia had looked up, but were not included in this report. But it's obvious there were numerous misconducts for him to serve out his entire time and not get parole. And then the other factor I'm looking at is nothing to do with acquitted conduct or the charges that had to be dismissed pursuant to that case, but also to admitted other crimes that he admitted to on the stand that will never get charged. The breaking and entering into those cars, and taking pictures of cars to send to people to help them steal cars, that's all additional criminal activity. And apparently Mr. Jackson-Bolanos, at the time of this offense, had not learned his lesson from all of his prior dealings with the judicial system and the prison system, and was still engaging in theft crimes on the night that this happened. And that's what put him in this place to begin with, and ended up having him charged with the more serious crimes. So it is the sentence of this court that Mr. Jackson-Bolanos be sentenced to a period of incarceration of 18 months to 15 years in the Michigan Department of Corrections, with 243 days credit for time served. He must pay $68 state costs, crime victim assessment fee of $130, court costs of $1,300, which is the amount this court has estimated the average cost of a case coming through this courthouse. It's my duty, sir, to advise you of the right to seek appellate review of your conviction and sentence. If you're unable to afford an attorney, one will be appointed for you. They'll be given transcripts needed to prepare your motions or an appeal. If you wish to seek an appeal, you have to sign and date your appellate rights paperwork and mail it to the clerk of this court within 42 days of today's date. Your client's already initialed the form?
Yes, and you can.
Okay, we will give him a photocopy to take with him.
And Judge, just for the record, you made a reference to my client lying on the stand. Like, that's unsubstantiated that he lied on the stand. That wasn't even alleged that Mr. Jackson-Bolanos lied on the stand, but this court made reference to he lying on the stand. And just for the record, Judge, he successfully completed his last probation he was on in 2018. So he demonstrated to the court that he does have what it takes to be successful on community supervision. If you're going back from 2013 when he's 19 years old, I mean, this is 11 years ago at his last probation that he didn't successfully complete it. 2018 was his most recent probation, and he successfully completed that probation, and they closed him out.
Sir,
Judge,
I've heard you out. He may have completed that one, but then he was out committing theft crimes the night of this event.
Okay, but Judge,
Admittedly.
Okay, but Judge.
And he's never gonna face charges on that.
Okay, so that's uncharged conduct, and Judge, if they wanted to charge them on that, they could have charged them on that. But in this building, Judge, we gotta be honest with ourselves. How many individuals get sentenced to prison for lying to the police, especially if they're not being charged with any type of larceny? That just doesn't
Yeah,
happen.
how many of those people are habitual fourth offenders? I'm done,
A lot
that is
of
my
them.
sentence.
A
You
lot
can
of
take it to the Court of
Oh,
Appeals.
well.
Defendants remanded to the custody of the Michigan Department of Corrections.